Hello and good afternoon. Thank you for joining us for this afternoon's webinar, the ABCs of Global Mobility. Also happens to be our first live webinar for the month of October, so thank you so much for joining us today. We have a packed presentation ahead of us, but first I would like to take care, just to mention a few housekeeping items. Today's session will last for about 45 minutes, and that includes audience question and answers. So if you do have a question, you should see a control box, a box of some sort on your screen from GoToWebinar. So please type that question in, and we'll try to get to it at the end. This webinar is being recorded, and we will send everyone a link to download the recording after today's live session. You'll also receive a link to download the slide deck. Those links will arrive via email tomorrow afternoon, so please keep an eye out on your inboxes for that message. And finally, you'll also receive continuing education credits from SHRM and HRCI in that message. For nearly 20 years, for those that are unfamiliar with Envoy, for nearly 20 years, Envoy has been on a mission to fix the frustrating, inefficient, and confusing immigration process. Envoy combines expert legal representation with innovative technology to deliver the only platform that makes it seamless for companies to hire, mobilize, and manage a global workforce. Envoy secures work authorization in over 150 countries, has grown 41% year over year, and works with over 1,000 customers. We are particularly proud of our NPS score, which is a testament to the employee experience that we provide. And very excited, we have a packed house today with 3 presenters, all from the global team here at Envoy Global. First, we are joined by Karima Hayes, Global Immigration Manager. Hannah Inchan is joining us, is a Global Immigration Manager for in the EMEA region. She's joining us from the United Kingdom. And finally, I would like to welcome Jim Yang on his first Envoy webinar. Jim is a Senior Global Mobility Specialist, and he is based in Canada. Thank you for joining us, Karima, Jim, and Hannah.
Hi.
Awesome. So before we jump into things, we want to kind of provide a brief agenda. So we're going to start by looking at the global economy, and then we're going to start with some very general, high-level global immigration terminology phrases that you should know, and then we're going to go very into region by region. Jim's going to discuss some Canada terms and themes, and then Karima will discuss Latin America and APAC, and then Hannah is going to discuss EMEA, and then, as I mentioned at the top of the hour, we will end with some questions. And finally, the content in this presentation, it is not intended as legal advice. For additional information, please consult with an Envoy-affiliated attorney or another qualified professional. All right, so let's hop into things. We'll start just kind of briefly looking at the global economy. So in a recent study from Velocity Global, 85% of U.S. and UK tech businesses are looking to expand into new overseas markets. This is thanks due to advances in communication and technology. So obviously we are more connected than ever, and as we're seeing more and more, business transcends borders. So as such, skill talent is at the core of any successful global expansion initiative that companies may undertake. In order to capitalize on these goals and whatnot, employees need to be able to hit the ground quickly. And we're seeing from our Immigration Trends Report from this year, in order to help employees move overseas, work in other locations, 39% of employers have a centralized team in the U.S. to handle the outbound immigration. And then another 34% have an internal global mobility team. So one of the reasons why we decided to host this webinar is if you're tasked with global immigration, kind of having that firm knowledge of basic terminology and region-specific considerations is very, very important. So with that, I'm going to turn things over to Karima to discuss some of the, like I mentioned, some just high-level global immigration terminology.
Sure. Thanks, Eric. At a high level, a business visa, and we'll start with business visa as it's generally the more commonly used terms in terms of business travel. A business visa is either a visa stamp or a sticker allowing for an individual to perform certain activities in country. So the activities that constitute business vary from country to country, and the determination between business and work activities require a professional legal analysis, given that it does vary from country to country. Moving on to an entry visa. An entry visa can also be in a visa stamp or sticker format. This typically allows for an employee to simply enter a country and doesn't necessarily allow them to conduct certain activities. Of course, this should be evaluated by a legal representative depending on that specific country and to confirm what activities are permissible.
Awesome. And I think then moving on, we have what's a residence permit?
Yeah, so residence permits, they're sometimes only required in certain countries, and it doesn't really always coincide with the validity of a work permit. It is common, but to also note that the work permit and a residence permit may vary in expiration dates. However, in other countries, a residence permit can also serve as a work permit.
And awesome. And finally, we have a work permit.
Sure. A work permit is generally defined as legal authorization to work in a particular country for a certain work activities and for a specific duration. The criteria for securing a work permit varies from country to country, as I mentioned, and at times this can also vary from provinces within a particular country as well.
Awesome. So thanks for this first section, Karima. So now I'm going to turn things over to Jim, who I mentioned is based in Canada, and he's going to go over some terms and themes around Canadian immigration. So Jim, I believe the first term here is IRCC. So take it away.
Thank you, Eric. So to start things off, we're going to look at some common terminologies we utilize in Canadian immigration, and I'll be explaining at a high level what each of these terms mean. So in Canada, IRCC, or also referred to as Immigration, Refugee, and Citizenship Canada, is the federal government agency that's responsible for processing immigration applications, including work permits, business visas, permanent residency, and citizenship applications. This agency also operates the Canadian visa offices that are outside of Canada, which are located in consulates and embassies in foreign countries, and their main responsibility is to ensure the proper administration of Canadian immigration laws and regulations. Next slide. Now, in Canada, there are essentially two programs in which a foreign national can obtain a work permit. The first being the Temporary Foreign Workers Program, in which a Canadian employer can hire foreign nationals to fill a labor and skill shortage by demonstrating that there are no willing or qualified Canadians available for the job. This demonstration is called a labor market test, and what we call an LMIA here in Canada. To offer greater simplicity, IRCC has simply grouped all the different work permit streams or categories in which a labor market test is required and referred to them as the Temporary Foreign Workers Program. Next slide. Now, in 2017, the Canadian federal government introduced an immigration plan known as the Global Skills Strategy to help Canadian businesses attract the talent they need to succeed in the global marketplace. As part of this strategy, they implemented the now permanent program of Global Talent Stream, which is a fast-track system that enables 2-week processing time for LMIA applications. This program is designed for employers seeking to hire unique or skilled occupations and is a stream under the Temporary Foreign Workers Program. Next slide. So the second method in which a foreign national can obtain a work permit in Canada is through what's called the International Mobility Program, or in short, IMP. Unlike the Temporary Foreign Workers Program, the objective of the IMP is to advance Canada's broader economic and cultural interests and include all the work permit streams and categories in which a labor market test is not required. The IMP work permit categories are based largely on bilateral agreements with other countries. For example, the North American Free Trade Agreement we have with the United States and Mexico. Reciprocal benefits to Canadians, and programs implemented by IRCC. Next slide. So in the Canadian immigration context, business visitors are defined as individuals who come to Canada and take part in international business activities without being a part of the labor market. And what this means is that individuals who are classified as business visitors do not need a work permit in order to perform their duties in Canada. To be eligible as a business visitor, the activities the person partakes in must be international in scope, and their pay, principal place of employment, along with their profits for their activities must be outside of Canada. Some allowable activities under the business visitor category include attending business meetings, providing or receiving intra-company training, and partaking in discussions with clients that advance business relationships. Next slide.
Yeah, I think that was the end of your section for now, Jim. So thank you so much for going over some of the terms and phrases regarding Canadian immigration. So now I would like to turn things back over to Karima to discuss some common terms and phrases that regarding Latin American, LATAM countries, for the region, I should say.
Thanks, Eric. So I'll just high-level go over Latin American terms and themes that we found common within certain jurisdictions. So company registration. Employers who wish to hire foreign national employees for employment purposes, such as in Mexico, must first sometimes register with the government or the immigration authorities. For example, to register the company in Mexico, a Mexican entity needs to present certain corporate documents to the authorities, such as its articles of incorporation, tax IDs, power of representations, and other documentation of the like. Similar documents are required for other jurisdictions, but it is important to note that not all visa types require a company to be registered with the authorities. For example, in Brazil, while the company does not need to be registered with the immigration authorities, some applications require certified copies of their corporate charter registered with the commercial registry, as it indicates their representatives and current valid of the capital stock.
So moving on.
Sure. Moving on to Mercosur. Mercosur is made up of 5 countries: Argentina, Brazil, Paraguay, Uruguay, and Venezuela, and is a South American trade bloc which was established in 1991. Its goals include to integrate the economy of its members and to promote the economic development within those countries. While American citizens typically require a visa to enter, for example, Brazil to work or conduct certain business visitor activities, these nationals that fall within these countries typically don't require visas, as they are separate immigration processes to these nationals of these countries. For example, in Brazil, nationals under these countries, as well as associated countries, which include Bolivia, Chile, Colombia, Ecuador, and Peru, can apply for a residence permit to live in Brazil, which allows them to legally work with no other requirements other than their nationality once they've presented their passport, birth certificate, and police clearances, and amongst other documents that may be required. In Brazil, holders of the Mercosur Residence Agreement also enjoy the same rights under civil, social, and cultural freedoms as the nationals within those countries, which means that they can essentially work for any company and perform any activities within that country under this status. For example, they can provide technical assistance without having to need a specific authorization versus an application for a U.S. national. In addition, the applicant can either apply for a visa at the Brazilian consulate in their country of residence and then come to Brazil to register with the federal police, or they have the option to also just directly apply with the federal police in country. So in sum, it's essentially a more expedited process rather than having to apply for the standard work or residence permit that requires analysis from the Ministry of Labor. Moving on to visitor status versus worker. So in some Latin American countries, they allow for visitors to enter to either conduct certain work activities on a short-term basis, or they require the applicant to actually enter in as a visitor, as the process requires their physical presence in country for that particular visa application filing. For example, in Mexico, the entering as a visitor allows foreign nationals to engage in a wide variety of activities in Mexico, so long as they're not receiving any salary from a Mexican entity source. These exempt nationals, such as U.S. nationals, can stay up to about 6 months as a business visitor. However, depending on what activities they're going to be conducting and how often they're going to be traveling, they may require supporting documents such as support letters, invitation letters, return flight itineraries, and proof of sufficient funds to travel to Mexico. Most foreign nationals will be granted an entry stamp upon entering, but other foreign nationals that require a visa would need to apply for a visitor visa prior to entering Mexico. Other countries, such as Panama, require certain visas to be applied for actually after arriving into Panama, and essentially requires the individual to enter as a visitor. So essentially, this is a change of status application from a visitor status to either a work permit or permanent residency, just depending on what that individual is applying for. Such as this new short-term visa that we found for U.S. nationals that was just recently released in mid of July. This visa allows for U.S. nationals to travel to Panama for work transfers, temporary work, or technical studies, and involves a more streamlined process that can be completed once the applicant has arrived to Panama.
Cool. Thank you for going over those terms and phrases regarding the Latin American region, Karima. So next, we're going to hop over the ocean to Hannah Inchan, who is our EMEA expert. So Hannah, what are some common terms, themes, phrases that our attendees should know about?
Thank you, Eric. So for our first term or theme, we'll be looking at the advertising requirement, or sometimes known as the resident labour market test. In some countries, certain categories of work permit require the sponsoring company to advertise the position before they apply for the work permit. For example, in the UK, when applying for the Tier 2 General Restricted Work Permit, the sponsoring company must advertise the position for at least 28 consecutive days and in at least 2 different websites, one of which is a UK government website, unless there are certain exemptions that apply. In Ireland, for example, the company needs to advertise the position with the Department of Employment Affairs and Social Protection Employment Services, or EURES, employment network for at least 2 weeks, in a national newspaper for at least 3 days, and either in a local newspaper or a jobs website for 3 days. And more countries are moving towards implementing an advertising requirement. For example, Switzerland in 2018 implemented their first advertising requirement for positions where the company will be hiring foreign nationals rather than a local Swiss national. So we're just moving on to the next slide, where we go to the Middle East. For clients and attendees who work with the Middle East, and in particular with the UAE, you may have noticed that the UAE operate a number of different free zones. These free zones utilize a special tax, customs, imports regime that are governed by their own framework of regulations. There are currently 37 free zones in the UAE at the moment. Each free zone have different immigration processes and criteria, and they generally created around different industries. For example, in Dubai, there's a technology free zone called the Dubai Internet City, also known as the DIC, or there's a finance free zone called the Dubai International Finance Center, more commonly known as the DIFC. I'm just going to hop on back over to Europe. So if we can go to the next slide, thank you. So looking at the Schengen zone and the Schengen visa. The Schengen zone consists of 26 member countries. 22 are from the EU, the European Union. 3 are from the European Free Trade Association. And we also have Switzerland. Switzerland is a bit of an anomaly in terms of immigration processes. It's not part of technically not part of the EU and technically not part of the EFTA, but they do, but Swiss citizens are actually given rights similar to EEA or EFTA and EU nationals. So they can come and work in the UK, for example, without needing a work permit. But do note that the UK and Ireland are not part of the Schengen zone. So when we talk about getting a Schengen visa, the Schengen visa is a single visa that allows business visitors to travel throughout the Schengen zone without needing additional visas. So one visa will allow the individual to travel throughout the whole of the 26 countries. But as I mentioned earlier, that the UK and Ireland are not part of the Schengen zone. So if the individual needed to travel to, for example, France, and then to the UK, they will need a Schengen visa to travel to France, and then a separate UK business visa to travel to the UK. Just moving on to the next slide, I'm going to sort of go through the terms EEA, EU national, and EEA national. EEA, as I mentioned earlier, is the term used for the European Economic Area. This is the countries that include the EU countries, which we've noted on the next slide for your reference. So when you download the slides following this webinar, you'll have a quick reference to the EU countries. It also includes the EFTA countries, Norway, Iceland, and Liechtenstein. As I mentioned earlier, Switzerland is not part of the EEA, but Swiss nationals do have similar rights to EEA nationals. So an EU national is a national who holds a national passport for any of the EU countries. They have free movement of the freedom of movement to live and work in any of the EEA countries. An EEA national is a national from the EU or any of the EFTA countries who also enjoy free movement of freedom of movement throughout the whole of the EEA. Moving on to the next slide, this is the slide of the EU countries, and UK is still listed in this slide, but we will find out what happens on the 31st of October, whether the UK do or do not leave the EU. So just briefly, that brings us nicely onto our next slide, which talks about Brexit. I'm sure most of you, if not all of you, have heard the phrase Brexit. It is the term that's given to the process for the UK leaving the European Union. Mixing Britain and exit, that's how they came up with Brexit. Although technically it's not Britain that's leaving, it's actually the United Kingdom that's meant to be leaving. But I guess Brexit sounded better than UK exit or something. So that's how they come up with that term. Just moving on to the UK sphere, which we are going to sort of quickly go over what is a settled worker. A settled worker in the UK does not need to have work permission. They don't need to apply for a work permit. They don't need to apply for a residence permit. Although, having said that, you may if you wish to. So, for example, I'll just go through the list of what's considered a settled worker. A UK national, an EU or EEA national, a citizen of the UK overseas territory, except citizens of the sovereign base areas of Cyprus, and a person who holds permanent residence or indefinite leave to remain. And I mentioned you may want to apply for some kind of a permit or a residence card. That is geared towards EU or EEA nationals. It's not a mandatory requirement at the moment, but if an EU or EEA national wanted to apply or obtain evidence of their status in the UK, they can do so. At present, their passport is enough, but obviously that could change following Brexit, and that we will be doing a seminar on Brexit in the near future, so tune in for more details on that. I'm just going to move on to the next slide and stay with the UK. Some of you may have come across the terms the SOC, which is the Standard Occupation Code, or the Shortage Occupation List. The Shortage Occupation List is a list of SOC codes that are exempt from the resident labour market. So I'm kind of bringing everything together, but also just a quick explanation on what these are. In the UK, each position that a foreign national will be filling needs to be compared or mapped to an SOC code. The SOC provides details on the minimum salary required, the expected job duties, and the expected job titles within that code. The SOC classifications are reviewed regularly, as is the Shortage Occupation List. If an SOC code is listed in the Shortage Occupation List, that means that the sponsoring company does not need to advertise the position, so they would be saving a minimum of 28 days from the processing time. On Monday, 7th of October, the UK immigration authorities announced a positive change to the Shortage Occupation List by broadening the scope for IT professionals and software programmers to be included in the Shortage Occupation List. They have also taken away the need for companies to be registered as a shortage occupation company. We are super excited about this, because this is going to, make the process for hiring or employing foreign nationals in the UK for that field, for IT professionals and software programmers, make it a lot easier. But we anticipate that there will be a huge number of companies wanting to utilize this newer change. So we're being very sort of hesitant about, well, not hesitant, we're expecting the UK VI, the UK immigration authorities, to change their mind in a few months, if not a year, and to take away IT professionals and software programmers from the Shortage Occupation List. So, we're expecting more changes to happen in the near future. But if you want more details about that, do let us know, or contact your immigration provider. But that is it from me, Mia. So back to you, Eric.
Awesome. Thank you so much, Hannah. And Hannah, as you were talking about Brexit, obviously, so we're about three weeks away from that October 31st deadline. And you did mention a Brexit webinar for our attendees. Just in case you may not have seen it, Hannah will be going deeper into Brexit on a webinar scheduled for October 24th. So if you want to register for that, you can head to envoyglobal.com/webinars and events, and you can secure your seat. And Hannah will be kind of diving deeper into Brexit on that day. Should be an interesting one there, Hannah.
Hopefully, it may be. Yeah, hopefully.
Awesome. So with that, I'm going to turn things back over to Karima for some terms and themes for the Asia-Pacific region, also known as APAC. We had some help with your colleague Patricia on this, but Patricia is based in Australia, and big time zone difference there. So I think so you're going to be covering the terms for her. So what are some common terms that our attendees should know?
Sure. So I'll start with APEC, which is also known as Asia-Pacific Economic Cooperation. So it's a regional forum established in 1989 to leverage the growing interdependence of the Asia-Pacific. So a popular program that was established from APEC was the APEC business card, which we have seen come across more frequently recently. So this card facilitates short-term business travel within APEC region by streamlining the entry process with the APEC economies. The apply once approach is used, which means that the applicants are only required to make an application for permission to enter participating economies. So successful applicants from fully participating economies are generally issued a 5-year card that serves as an entry authority to other participating economies, which have granted pre-clearance for short-term business travel. This card also enables holders to fast-track immigration processing at each economy's major international airports. While this is applicable for certain regions, the U.S. is a transitional member, which means that it does not have the same entry arrangements for U.S. nationals as of other countries. But the card does provide some fast-track immigration processing at major international airports. Moving on to updates regarding eligibility for dependents. We have seen a significant change in APAC immigration laws regarding eligibility for dependent applications. Dependents are typically defined as the spouse or a child of a main applicant worker, and their applications would in turn need to present a marriage certificate or a birth certificate to show the relationship between the dependent and the main applicant applying for said work permit. However, we've seen in recent months and years the definition extended to same-sex partners in a few countries, which include Australia, New Zealand, and Hong Kong. It's important to confirm the country-specific dependent eligibility requirements, as there may be age limit requirements when it comes to children. Otherwise, the applicant may need to look at other options, such as student visas or tourist visas, depending on how long they will need to stay in that country and what activities they'll be conducting in that country. Moving on to the ICT. ICT is also known as the intercompany transfers. It's widely common across APAC jurisdictions as well as other jurisdictions around the world. So it typically consists of employees who are employed with a foreign branch or entity who are then transferred to another entity. They are then sometimes eligible for a more streamlined process and may require less documentation from the employee or the corporation, as they hold essentially a specialized knowledge, and the role may have required them to have previous experience for working with that company. The ICT category is extremely common, again, within certain jurisdictions such as Japan and India. In certain instances, this route allows employers to keep their employees on home country payroll, dependent on their qualifications, and then given that they're more likely to repatriate upon completion of their assignments. We also know that there are quotas implemented in a few of the APAC countries, similar to other jurisdictions. Quotas may consist of confirming the entity's local hire headcount prior to sponsoring and extending offers to foreign nationals. For example, the cap in Australia was just recently cut by 15% by the Morrison government. So from 190,000 migrants, it will now be reduced to 160,000 migrants for the next 4 years. And it introduced new skilled worker visas to steer migrants away from larger cities. Similarly, in Singapore, the Singaporean government will reduce the ratio of foreign workers in the service sector from its current cap of 40%, and starting in 2020, employers will only be allowed to employ foreign workers and work permit holders up to a cap of 38% of their total workforce. And re-entry permit is required by some countries for either their citizens or tourists who leave the country for an extended period of time. For example, in Thailand, if you have an extension of stay or a simple permit to stay in country, whether that's a tourist visa or in a tourist status or a non-immigrant visa, but would like to travel outside of Thailand for a short period of time, that individual would need to then apply for a re-entry permit to re-enter Thailand. Indonesia also issues re-entry permits to work permit holders, so it's incredibly important for employees and employers to both understand immigration requirements pertaining to exiting the country for whether it's tourist or business purposes, as it can significantly impact the applicant's current immigration status.
Awesome. Thank you, Karima, for covering the Asia-Pacific region. And that's going to bring us to the end of the main presentation. So again, we're going to open the floor for some questions if there are questions. So if you do have a question or two for Karima, Jim, or Hannah, please type it in and we'll try to get to it. So as we wait for for some questions to roll in, I just want to quickly highlight some upcoming webinars we have. Next week, we're going to offer a beginner's guide to the H-1B lottery. So if you want to know more about the H-1B lottery, please sign up for that. And then additionally, we're also having a session on the definitive guide to H-1B alternatives. And then if you take a look at your screen, when you receive the slide deck tomorrow, that link at the bottom will be clickable. That's where you can see a list of all of our upcoming webinars, including the Brexit one that I mentioned a couple of minutes ago. As always, please be sure to subscribe to our mailing list and visit us on social media and our website to stay update on the latest news and receive the latest webinar and event invites. And finally, we have SHRM and HRCI continuing education credits for today's session. So if you would like, please take a second to copy this down. Again, these will also be sent in tomorrow's follow-up email. All right, so just a quick question. So we're about 1:38. I think we have a couple questions. So Hannah, can you kind of provide the the latest update, very general update on Brexit? As we're a couple weeks away from October 31st.
It is the status quo. We don't really know what's going to happen or if it's going to happen. I was about to say David Cameron. I don't know why he's in my brain. But Boris Johnson, our Prime Minister, as opposed to our former Prime Minister, who started this whole process, Boris Johnson has recently, last week, he submitted his latest proposal to the EU for a deal. We're waiting to hear back from the EU, but early indications are telling him to go back to the drawing board and to rethink his proposal. So it looks like potentially there's going to be no deal. Mr. Johnson has indicated that he will take the UK out of the EU on the 31st of October, with or without a deal. But the UK Parliament is opposing that, and there's currently a lot of legal movement, a lot of appeals and going through the courts with regards to Mr. Johnson's actions. So there's a lot going on, a lot of it behind the scenes, but effectively we just don't know what's going to happen. We may leave on the 31st, it may be delayed, but the UK do have plans for post-Brexit, and I'll go into that further during the next webinar.
For sure. Awesome. Thank you. Also, so awesome. Jim, there's a Canadian election this month, correct?
Yes, that's correct. Yeah, the Canadian election is happening on October 21st. Now, depending on who gets elected, we might have a switch in the kind of immigration legislation. However, most of the programs that we talked about today, in my opinion, I feel like there won't be major amendments to them. But yeah, in Canada, we're also I don't know if we're looking forward to a new election. But yeah, there's definitely going to be some changes in the with the Canadian government and also with the immigration legislations.
Awesome. And that's, again, October 21st?
That's correct.
Cool. Awesome. I think that's all the questions we have for today. Yeah, I just want to keep things very high level. Can't get into any specifics on this webinar, so please consult with legal counsel for additional help or information. Hannah, Karima, Jim, thank you so much for joining us this afternoon. We're going to end things 4 minutes early, so give everyone back 4 minutes in their afternoon. To all our attendees, thank you so much for joining us. And again, please keep an eye out on the follow-up email tomorrow afternoon. If you don't receive it, please let us know, and we'll be sure to get that to you. So thank you so much, and have a great rest of your day.